Number 117, the people of the state of New York versus Saylor Suazo. Counsel?
May it please the court, I am Mark Zeno and I represent appellant Saylor Suazo. I ask to reserve 2 minutes for rebuttal, Your Honor.
You may, sir.
Mr. Suazo asks this court to rule as the en banc D.C. Court of Appeals did this past June in Bato versus United States, that the Sixth Amendment guarantees a jury trial to a criminal defendant who faces the penalty of deportation if convicted, even if the maximum sentence that the court can impose is less than 6 months.
So how is deportation a punishment if he's already deportable?
Let me provide two answers to that question. First of all, it was not clear at the time that counsel made the motion that the defendant, Mr. Suazo, was deportable. That his lawful status or his out of status is actually not part of the record on this appeal. So as a preservation matter, the question is whether deportation, whether a defendant who is deportable is entitled to a jury trial.
So if we're fashioning a rule, though, that's going to be applicable
I
to
totally
beyond
understand
him.
I understand where you're going, Judge, but I just wanted to clear the air with the preservation piece of it.
But let me ask you this: is the rule tied to the crime, or is the rule tied to, in other words, the deportability of anyone who commits that crime, or is the rule tied to the individual defendant?
It is necessarily tied to the individual defendant, because the defendant's status, and there are a variety of statuses that a non-citizen can hold, is a necessary function of determining whether a crime will make them deportable.
So how would you propose that the court determine the defendant's immigration status? Would there need to be a separate hearing? Would there need to be certification or proof offered? How would it be done?
Well, the first place would be the defendant would ask for a jury trial because a conviction would lead to deportation. If the people challenge that question, then there could be further inquiry on that issue. There could be further lawful inquiry. The defendant could state under oath what his status is, and there could be a determination of whether and how a conviction of the charged crimes would affect them, and whether it would lead to their deportation, or whether it
What
would...
confuses me about that argument, though, is that we're talking about the seriousness of the crime, I think. And I think the Ninth Circuit once said that the offense isn't serious because it's severely punished. It's severely punished because it's serious. So I'm not clear about the necessity of, I'm not sure I agree with you about the necessity of the trial court getting into the weeds, if you will, of each individual defendant who claims that they're entitled to a jury trial, of his or her status and what that means for deportability or...
Well, I think there are some crimes there are some categories of crimes for which no further inquiry is warranted. For example, if it's an aggravated felony, that's mandatory deportation.
Or a domestic violence crime.
Or a crime of domestic violence, mandatory deportation,
so
regardless
only
of
if it's
status.
not obviously a crime of that nature, then you would have to get into the individual?
If it's not a deportable offense.
What about Judge Feinman's point, which I believe is, what if he's deportable already, and this is a deportable offense? So then isn't the punishment, under your view of it, the difference between the terms of your deportation?
No, because even someone who is deportable already may have paths to lawful status. If my client is from Honduras, for example, he has even though he overstayed his visa and was out of status, he may have had a lawful path to legal status as an asylee.
Would the court have an obligation to notify ICE?
No.
Someone comes in on the record, says, I broke this law, and you don't have any obligation.
I'm sure that the court has no obligation. I think there are policies in New York State that at the very least discourage courts from contacting
But would the
I-
client then have to come in and prove that they have this path to not being deported? Say visa overstay, they're fairly limited in what they can claim. So it's the chance to avoid deportation incrementally over the fact that you are deportable? You start to get into very different shades of punishment there, don't you?
Well, the punishment is ultimately the same. The punishment is deportation. Depending on the defendant's status, there are different paths and different likelihoods of whether deportation will result, depending on the crime.
Just step back just for a minute. This would be a very different application of this precedent in that most of the cases, or all, seem to speak to what the state has determined is a serious crime by looking at how it's punished. In this case, if we go with your rule, it would seem that the federal government is making that determination for the states. Because they're saying these crimes are deportable offenses. So now the U.S. government is saying that's a serious crime.
I agree with you, and that is because Blanton leaves open the question of if even crimes that are punishable by 6 months or less imprisonment may be serious crimes if the legislature deems them to be serious by the nature of the penalty. And here,
And you're
Congress-
interpreting legislature to mean Congress or the New York State legislature?
For sure, Congress is our national legislature. It specifically, in the legislative history beginning in 1917, when it identified crimes that should be deportable, has used words like, we deem deportation appropriate because these are serious offenses. And that's precisely what Blanton, in Blanton, the
So
Supreme Court asked us to look at.
where does that rule leave us? There are many other kinds of consequences of this type of conviction that are penalties imposed by the federal government, not the state, or perhaps imposed by both. So where do we draw the line? Is it just a deportation?
Well, I don't think we have to draw that line today, but since 1989, no appellate court has found another collateral consequence to be serious punishment.
What makes deportation different?
Well, deportation is different, and that's, I think, what Padilla, the Supreme Court said in Padilla versus Kentucky, that it has become, since 1997, an inseparable part of a criminal conviction for a non-citizen. It is often more important to the defendant that they avoid deportation than even lengthy prison terms that span years or decades. Staying in the country, close to family, close to their home, is more important to them than the prison term. And particularly in a shorter prison term, it's far more important than, the U.S. Supreme Court set the line at 6 months imprisonment as the...
Do they end up in immigration hold?
And they can often end up in immigration hold if you have been convicted, as I talk about in my brief, if you've been convicted of a deportable offense, detention is mandatory, and they can spend months and months. And in fact, my client spent more than 6 months in detention.
Thank you, counsel.
Thanks.
Counsel?
May it please the court, Noah Shamoy for the people. This court should decline to adopt Beto on principle that it is not persuasive authority. Beto is in fact the first court to ever look beyond the legislature that passed a criminal statute to decide whether or not a right to jury
Has
trial
that issue ever been raised before?
In fact, it has many times. 4 states, 3 state Supreme Courts, New Jersey, Nevada, and Arizona, and an intermediate court in Kansas all said we do not look to Congress, we look to our state. The federal circuits are unanimous. We only cite to 2 of them in our brief, but in fact, many more have said the same thing, what's called the Assimilative Crime Act. And basically it's reversed, which is that statute requires the procedures of the federal government to basically match the state to protect, to make sure they're not being treated differently depending on who chooses to prosecute. And so many defendants said, well, in our state, say South Carolina as an example, there's a jury trial for everything. Consequently, the federal government must give me a jury trial. And the circuits have said unanimously, no, for jury trial rights, we look to Congress because the federal government is the one prosecuting, not the state of South Carolina.
Well, here we're looking to the constitutional right to a jury trial, so let's just stick with that one and this division that the court has set up between petty and serious offenses. So why shouldn't we consider this national consensus, what the Supreme Court has set out as how serious deportation is? It is an exile from this country, never to return. Why isn't that serious enough to distinguish deportation from other kinds of consequences?
Well, there are two answers to that. First is that the penalty authorized by the law of the locality is what is taken as a gauge of its social and ethical judgment of the crime in question.
Where does it say that?
Duncan v. Louisiana, citing Klons.
But then the court in subsequent cases, Baldwin and Blanton, isn't the court looking at the nationwide consensus?
No, it is not. Interestingly enough, it looked at the nationwide consensus up through Baldwin to determine the objective standard that it was going to create. It was a long history of removing the common law and ultimately coming to an objective test. But it never crossed the line of saying that objective test goes anywhere further than the locality.
But isn't the federal government the only legislature that can impose the penalty of deportation? So
That is
so
true.
that's not something that a state ever could do, and yet both the Supreme Court and this court have recognized immigration consequences as being very, very serious.
Well, that is true, Your Honor. However, the fact is that what Congress has chosen to do in this case is to create an immigration statute. Oh, I'm sorry. Let me answer first the initial part of your question, which is deportation being unique. It is only unique in the sense that it is one of many things Congress has exclusive authority over. It has exclusive authority over interstate commerce, the military. There are collateral consequences that can attach that through preemption they can pass laws that would govern states for many different things. And as a consequence, such as federal housing, which in reality controls housing for New York. All of these things become consequences that once we say, well, it's something in the control of Congress, states don't actually have that specific control, so we can look beyond the line.
But that doesn't
They
mean
become
that all
factors.
of those things rise to the same level of severity or seriousness.
Which is the next part of my answer, which is courts have declared it to be a severe penalty. Padilla did, and it was relying on a line of cases, and Peck even did. However, there was a recognition in every one of those cases that when it was defining it as a severe penalty, it was looking to the individual. It was looking exactly the way Blanton doesn't. It was flipping the analysis. It was looking at the individual, and subjectively to an individual, it can be a severe penalty.
Well,
Well,
one of those decisions said that the court has to inform the defendant that there may be immigration consequences, right, Peck?
yes, Your Honor, Peck.
Right. So that didn't say that that the court had to make a determination as to what the consequences were for that individual defendant.
Correct. Peckway, interestingly enough, limited itself to felonies. It didn't address what's at issue here, which is B, misdemeanors and violations, and it actually states why, which is unlike of an aggravated felony, which is almost all felonies
Well,
in New York.
how can we square the following? First, that outside of New York City, any other defendant would get a right to a trial for the crimes charged, right, for those,
Yes.
the B misdemeanor. And that New York, with another small number of states, are outliers, right? Most states do provide jury trials. How can we square that in the analysis here? Or do you think it's completely irrelevant to the analysis?
Well, as for the geographic issue regarding New York City versus the surrounding areas, this court previously decided that issue in Hogan v. Rosenberg and said there is no equal protection or other problem with that, citing to U.S. Supreme Court case that
Yeah,
actually
but there's not an
specifically
equal
turned-
protection argument here.
Correct.
No,
But it-
the question is whether or not the legislature, let's say we agreed with you that we can't look outside of the boundaries of New York State and Albany for our legislature's sensibility about whether or not it's a serious crime. How do we get past the fact that everywhere outside of New York City, it's serious enough that you get a jury trial?
Well, in New York, as I said, that is a distinction that the legislature was allowed to make, authorized to make, and did make. And the Supreme Court has even recognized that jurisdictionally, it may be, for purposes of efficiency, that large cities require different judicial
Yes,
administration.
I'm not making myself clear. Yes, I'm not making myself clear that
you
I'm
mean
not
nationwide.
asking you to discuss the lawfulness of the legislature's choice, right? The constitutionality of it, or otherwise, whether it's as a legal matter problematic. My question is, having made that choice, that as you correctly point out has been upheld, doesn't that give us a basis to say the New York legislature thinks it's a serious crime? Even if it is a Class B misdemeanor, it's serious.
Well, the New York legislature was very careful, and in fact, its history of how it came to writing the statute.
But it's sort of the other side of your argument. One side of your argument says that a non-citizen would have a greater right under the appellant's theory than a citizen. That's one side of the argument. The other side of the argument is, well, why should someone who lives in Binghamton have a different right to a trial than someone who lives in Queens?
Well, as to the latter issue, that is actually not an issue presented by the parties to this litigation, to be clear. That was
Well,
actually
answer it
raised in the
anyway.
case. Absolutely. The fact is, as I was just saying, basically it comes down to this. Legislatures have the authority to create petty offense exceptions. We know this. We also know from Blanton and the language in it that it is what that legislature attaches to the offense.
But why isn't this a reasonable conclusion, that the legislature decided to give everybody in the state the right to a jury trial for this sort of a crime because they determined it was serious enough that it required a jury trial, except in New York where things were so congested that they couldn't do what they wanted to do even though it was that serious?
There would have to be evidence of legislative intent behind that, but
Is there not?
There is evidence that they consider it worthy of a jury trial outside of New York City, yes. But there is also evidence that they don't consider it truly to be a serious offense because they chose to create the petty offense exception.
I want to ask you a practical question, which is, how many prosecutions are we actually even talking about in a given year? Because it is limited to the city of New York, and frankly, based on my experience in the city of New York before I got to be here in Albany, this is really a Bronx-specific remedy in most instances for dealing with congestion or whatever motivations may motivate the prosecutor to move to reduce it. And then even within that subgroup of cases, you're talking about only those that are prosecuted against non-citizens. So give me a best estimate. We're not talking scores and scores of cases here.
I won't engage
that would require to now get jury trials.
I'm not going to engage in guesswork. I can say, because we previously filed the brief in our bias, that there are tens of thousands of defendants who are charged with Class A misdemeanors in New York whose cases are reduced, upwards almost to 100,000 back in the day. I can't answer for now. However, of those, the reduction to a B misdemeanor for purposes of trial is actually common in all of the jurisdictions of New York City. And the number of non-citizens is conservatively estimated at over 500,000, and that's a very conservative estimate of the population of New York. So all told, it is an extremely large number, and it only takes a few of them because
I'm sorry,
of the...
what was the 500,000 non-citizens
It's a
total?
non-citizens
Not
in
those
the
who are
city.
charged?
No, no, no.
Okay,
That's a
that's, I think, the
conservative
number
estimate.
Judge Feynman is asking.
Correct. But we couldn't say, because we wouldn't know that information, how many of the non-citizens are charged with crimes, because that's not part of our investigation. That's not information. that
What I'm
Counsel,
getting
speak
at
to the
are you
procedure
really
that-
opening a floodgate if you allow jury trials in this limited category of cases?
I think the bigger problem is when one is offered, that those who could claim to be a non-citizen, which includes, unfortunately, because there's no database of it, citizens who either believe they're non-citizens or simply want to cause delay,
That
actually-
becomes a practical question that I'm going to ask him when he stands up
Correct.
about
Okay.
how to fashion
So,
this
counsel,
rule.
would you speak to the procedure that would be required or proposed to be used for the
Well,
trial?
if I may, it's going
Yes,
to take a
please, go
moment
ahead.
because
Yes.
this case epitomizes the problem. In this particular case, as I understand it, my adversary's position is his inadmissible client is charged with what's called a particularly serious offense. The problem there is, in order to determine a particularly serious offense under federal law, unless it's an aggravated felony, for which we're not dealing with here, you need the record of the court below, meaning you'd actually have to have your trial first. So you would have your trial to find out the facts, then you'd have to find out the immigration consequences, and then if it turns out he was deportable as a particularly serious offense, because those are the facts that you found by the immigration
Why
court.
can't you just tell by determining the nature of the crime with which the defendant is charged? Isn't
Your Honor,
that the issue?
I
I mean,
was-
it doesn't make sense to me that you'd have to hold the trial first.
I was getting right there, Your
There's an accusatory instrument.
Yes.
And that, to me, would be the basis. And then in some cases, it seems to me that it would be pretty easy to determine whether this is a deportable crime or not. And in other cases, it might not be so easy, and the burden, I think, is on the defendant to establish that it is a deportable crime, because that defendant has to rebut the presumption that it is not a serious crime.
Your Honor, actually, I was getting right there, which is the complaint in this case, if you read it, does not actually state a crime of domestic violence. Ex-boyfriend is not under federal law domestic violence.
Well, it may be
And-
here that defendant didn't make an adequate showing. That's a
I'm sorry, Your Honor, I don't mean a showing. I mean that if we're saying we can rely on what's happening before trial, the answer to that question is not really once you get into the weeds of B misdemeanors and violations. The fact of the matter is, in this case, it said on the complaint ex-boyfriend. That is not an intimate partner for domestic violence law. It also identified 2 children, but did not identify them as in
And
common.
why can't the trial judge do one of 2 things? If the proof is not there, then you deny the jury trial. It's not, you don't go ex post facto to figure out if indeed, it's based on what is known to the judge at the time the argument is made, or the judge can err on the side of caution and give the defendant a jury trial.
Well, Your Honor, I believe the answer actually could be found in Beto, because in Beto, when they actually decided, it's okay, we can do this, they said the following, and this will, if I'm permitted. Government counsel are part of the Department of Justice, which has deep expertise in immigration matters and is part of the same executive branch as the Department of State and Homeland Security, which have responsibility for enforcing immigration laws. Defense counsel has an obligation to advise their clients competently on the question, and if necessary, the court presiding over criminal prosecution can appoint its own expert advisor in immigration law. That is now the standard in the District of Columbia, to have basically a massive hearing on immigration in every case. That is the only way to reach that conclusion here, only we have none of those experts.
Thank you, counsel.
Thank you, Your Honor.
Mr. Zeno? Mr. Zeno, did defense counsel have to have an expertise in immigration law under this?
Did defense counsel? Defense counsel worked for Bronx defenders, and since Padilla was decided, every defender office in New York City, which is the only place where this issue arises, has a staff of immigration lawyers. That's a constitutional mandate, and their purpose is to advise defense lawyers about the consequences of convictions, whether they be Class B misdemeanors
But counsel,
or
going
felonies.
to that, and Padilla has some very strong language that we've talked about, but Padilla itself also says there may be some cases where this is clear and you have to say this is deportable, but the language, I think, is that there are undoubtedly numerous situations in which the deportation consequences of a particular plea are unclear or uncertain, and all that's required in that case is an advice that that the charges may carry a risk of adverse immigration consequences. So that's the professional standard set by the Supreme Court. And I think that would be the majority of cases. They may carry adverse immigration consequences. So whatever this is going to show, that's the standard under Padilla. Wouldn't the rule ultimately just come down to every non-citizen gets a jury trial?
Well, if the court were to impose that rule,
But how else could you practically do it if the vast majority are being held to a Padilla standard of this conviction may carry adverse immigration charges?
Well, we're talking about a subset of criminal cases, Class B misdemeanors, which is the lowest level of conviction.
Which may be even harder to determine what the
And it
immigration
may be harder to
consequences
determine, and I
are.
think that if you look at Blanton, it says if the penalty is, the maximum penalty is a possibility, it doesn't look to the penalty that's actually imposed, it looks to what is the possible maximum penalty, and if it is deportation, in that may situation that you're talking about, then you get a jury trial. And what is the harm? In the rest of New York State, And most of the rest of the country, you get a jury trial. It's only in New York City that you
Well, then
don't
you're sort
get
of saying you don't need to look at the characteristics of the particular defendant, right?
I'm sorry?
You're saying you don't need to look at the characteristics of the defendant.
It would be the extremely rare case that you would need to look at the
Well,
characteristics.
you would look at one characteristic, because it seems like any rule other than you're a non-citizen is
So-
unworkable.
As a practical matter, how is this going to be implemented? Do you want to, should we put the burden on the, if we were to agree with you that it's serious and so on? Is the burden going to be on the defendant when the people move to reduce, to say, or perhaps is even charged at the outset with the B misdemeanor? Judge, I move for a jury trial?
Absolutely, the defense has to ask for the jury trial, as they did here.
Okay.
So I always like to think about what the next case is going to be whenever one of the cases comes in front of us, particularly on an important and interesting issue like this. And it seems to be the next case is if myself, Eugene Fahey, was convicted of a B misdemeanor in New York by a bench trial, the first thing I do is challenge the constitutionality of a non-citizen getting a trial and by jury, and me not getting a trial by jury. Wouldn't that be a consequence that really inevitably we would be striking down the non-jury caveat for the city by making this decision?
No, I don't think so, Your Honor. The state distinguishes between classes of defendants. If indigent defendant gets under the Sixth Amendment, gets a lawyer assigned to represent them. If they can't afford it, a wealthy defendant has no right to that lawyer. That doesn't invalidate the wealthy lawyer that the wealthy defendant that says, I'm entitled to a lawyer. It doesn't invalidate the system. I mean, Blanton says, look at the penalty and work backwards from there. Here, the penalty is deportation for a non-citizen, and that requires a jury trial.
Judge, may I ask?
Yes.
Judge? I'm sorry, I know your time is over, but I saw also in your papers below, and I think you continue to press it here, you have made an independent state constitutional argument.
We did.
You didn't?
We
You
are
have
not
not?
pressing a state constitutional argument because I think the state constitution is clear that it protects the right to a jury trial only where there has been an indictment, and I think that was the problem in Baldwin.
So you're not making an independent state argument? Okay, thank you.
Thank you, counsel.